This is part 2 of Chapter 3 on Federalism, dealing with American democracy now. We're going to continue talking about state sovereignty. Remember that the term sovereignty deals with authority. The Constitution is less explicit about what powers are reserved to the states. It does address electors or individual congressional representation and how that's determined. It also goes into formal amendments and the process of how to amend the Constitution. Remember, you need 2/3 of Congress to get a vote and 3/4 of the states to ratify. Why was the Constitution not explicit about state power? This is because the original state governments were already set. They had their own constitutions that they had already implemented at the time. They were only delegating a few powers specifically to the federal government. In addition to that, the Bill of Rights also protected state power with the addition specifically of the 10th Amendment. So not only did the Bill of Rights protect liberties for individuals, it also protected state authority. To reiterate, when looking at state sovereignty, we look to the Reserved Powers Clause. That's in the 10th Amendment. And that amendment states that any power that the federal government doesn't have is delegated to the states. Other powers that are delegated in the Constitution have to do with electors or congresspeople. And so not only does the state government have power in determining district lines, they also allow citizens to vote in representatives to the House. And at the start of the Constitution, or the beginning of the Constitution, we see that state legislatures were also appointing their senators, and this changed with the 17th Amendment, then giving it up to the popular vote. But these are both ways in which states have been given power. States also have policing power, which are powers or responsibilities to protect their citizens. As I mentioned, the states have the right to draw their boundaries, and this brings us to the concept of gerrymandering. Gerrymandering is the drawing of irregular boundaries to favor or disfavor a certain group. So this is really common in your solidly red states or your solidly blue states. If you look at California, for example, which is consistently a blue state, we know that we can look to many pockets throughout the state that are pretty solidly red. But often when we look at the political party that may be in power, they're going to have a disproportionate amount of say in what those lines look like. So for example, if we look at the district you live in, when you look at Folsom or the city of Folsom, it tends to be rather red. But when grouped into a district with an area like Elk Grove, you find that that can filter out a lot of the red and become more solidly blue. Now, federal law does state that gerrymandering for partisan purposes or to exclude groups or minorities is illegal, but we do see some level of it, even if it doesn't fit into these categories, as dictating the boundaries that we see today that dictate districts. To recap the powers of the national government and the state government, we can see those powers listed here, as well as concurrent powers, meaning powers that are shared by both the national and state government. And we see overlap. We know that this deals to conflict. It can deal to the national government not agreeing with state governments and vice versa. So what entity or institution is in place to hash out these differences or to make decisions as to who has the authority? This is where we can look to the Supreme Court. The role of the Supreme Court is important because it can hash out the differences or conflict between national authority and state authority. Often the courts do have very vague interpretations, invoking the necessary and proper clause in conjunction with the general welfare of the people, as we see in the preamble of the Constitution. But the Supreme Court does have the final say over what the Constitution means. The Great Depression played a major role in the expansion of federal power and the federal government. And this is where we see the concept of looking out for the general welfare, again, as stated in the preamble of the Constitution, is best interpreted. So when we look at the New Deal, this is a response to the Great Depression, and this is where FDR implements programs to try to stimulate growth in the U.S. economy. An example of legislation passed with the New Deal was the Social Security Act. There were states that challenged that act because it infringed on their police powers, but the Supreme Court ruled in favor of the national government as usual. Even though the track record of the court was to rule in favor of the national government's authority, there is an example of where the court ruled in favor of the states, and this had to do with the Gun-Free School Zones Act of 1990, as mentioned in the previous lesson. This was considered unconstitutional because state governments had the authority to police powers. The federal government may have had the authority over this legislation if the gun-free school zones were more directly related to commerce. But in this case, the court saw it as a stretch. Next, let's talk about horizontal federalism, and this deals with state-to-state relationships that we can find in the Constitution. So this deals with interstate compacts or agreements between different states. This may have to do with the usage of shared natural resources. In this respect, the national government will respect these agreements that are made between states, as long as there isn't conflict. When a conflict arises, that's when the federal government has to step in, or if it affects other states and is at a detriment to other states that are not involved in those agreements, that's where the federal government may step in as well. Another example between states is extradition. And so if a crime is committed in one state and an individual has fled to another state, it is an obligation of that state to send that criminal back. Expanding on horizontal federalism with regard to citizen treatment, we can look to the Privileges and Immunities Clause. Within this clause, a state must extend all citizens the same treatment as citizens of the same state. So this avoids discrimination. This excludes, however, some reasonable requirements like having to pay out-of-state college, for example. This is because if a citizen of a state has been paying taxes for an extended period of time, those taxes obviously would qualify them as enjoying those benefits, whereas an out-of-state resident may have to wait several years before they qualify. I should clarify, years might be an exaggeration. In most cases, it's about 1 full year. That brings us to the full faith and credit clause, in which all public acts, records, or judicial proceedings of one state are also legal in others. An example would be recognizing marriage licenses of other states. This also includes same-sex marriages. As we can see, the intergovernmental relations have risen due to the many levels of U.S. government. So this has to do with interactions between local governments, state governments, and national governments. That is what intergovernmental relations is implying. And it's evolved from a very simple system to a much more complex system over time. You should be familiar with the evolution of federalism in the United States. So let's start with how federalism began. It began under the concept of dual federalism. This could be considered the OG system, where government took care of its powers and responsibilities, while the states independently took care of their reserved powers. This lasted from 1789 to 1932. So state government was sovereign in its authority, and the federal government was sovereign in its authority. This changes from dual federalism to cooperative federalism, and this is the result of FDR's New Deal and the response to the Great Depression. The national government supported state governments' efforts to address their respective domestic issues, and it was a mechanism for grant-in-aids. So this is from the New Deal to the 1960s. The next area of federalism is centralized federalism, and this refers to Johnson's presidency with the implementation of the Great Society. This is where the national government imposes its policy preferences on state and local governments. And some precedents fight against this. And this is what leads to devolution. Presidents like Richard Nixon and Reagan, for example, tried to devolve much of the power and authority that ended up in the hands of the national government back over to the states. Conflicted federalism, which is modern day federalism, is the interaction between all three mentioned federalism categories that we talked about. In some cases of policymaking, The state and national government act as their own sovereign entities, utilizing dual federalism. Sometimes we look to cooperative federalism, where they have to work together, maybe having similar agencies that are working with one another, or it may be more centralized, meaning it's coming down from the central government. Either way, we see a lot of conflict play out and disagreement among people on who has that authority or what has that authority. There are several amendments dealing with the concept of federalism. The 14th Amendment, for example, is what really reshapes the Constitution. It authorizes the national government to ensure states adhere to the Equal Protection Clause. In addition to that, it also incorporates many of the amendments under the Bill of Rights to be incorporated and to be respected by state governments, not just the federal government. This is done through the Due Process Clause. So the 14th Amendment is what really empowers the federal government to hold the states accountable. The 16th Amendment increased national government's power through the ability of collecting income taxes. So without money, you can't be all that powerful. Once the federal government is able to collect these taxes through employers' paychecks to their employees, this makes it a much more efficient process and allows for that money to be available. It also provided leverage for domestic policy. So there is a saying, he who has the gold makes the rules. In this case, this can serve for mandates or regulations that the federal government can impose on the states that if they want that funding, they must be able to adhere to. And then lastly, looking at the 17th Amendment, this is where we see that senators are no longer appointed by their state legislatures, but rather that they are popularly elected. So I know that I mentioned how money can be used to get the states to favor policies that are coming down from the federal government, and this can be done through grants. So there are a few different ways this can be done. First, through the categorical formula grant, and this is money from the federal government for narrowly defined purposes to states with strings attached. So an example would be conditions that include matching funds by the state. So whatever the federal government puts in, the states have to put in as well. Another example is the categorical project grant, where states compete for national grant money with specific projects. Block grants tend to be more favorable by states. So in contrast to the categorical grants, block grants provide a broadly defined policy set of areas. And originally it had fewer strings attached. They're starting to increase with those strings today, but either way, it allows for states to do more or make decisions, have more broad authority over making decisions as to what they do with the money that they receive through block grants. So block grants are an example of how power has been devolved back to the states. Other examples include mandates, and these are clauses in legislation that direct state or local governments to comply with national legislation or standards. Oftentimes, unfunded mandates cause conflict between states and national governments, mainly because when there is a mandate that is being imposed on a state and they have to fund the implementation of it, that doesn't go over too well. Some examples of mandates would include increasing the drinking age in a state to secure funding for roads and bridges, for example, or the Affordable Care Act, if we look at mandates to expand it, that being required in order to receive any funding altogether for, let's say, healthcare or for Medicaid. Preemption is another principle that allows national law to supersede state or local law. So an example of this would be the federal minimum wage, which is set at $7.25. And this law has been imposed upon the states. However, many states do not honor this. Now, state governments, however, do have to honor the minimum wage, but private businesses within states don't necessarily have to adhere to it. Now, the state or local government themselves can require the citizens of that state or local authority to do so, but it is not something that can be imposed by the federal government, with the exception of it being state government jobs. This is the end of the lesson for part 2 on federalism.